The central issue is whether the International Emergency Economic Powers Act, IEEPA, a 1977 statute, grants the president the legal authority to impose vast country-specific and global import tariffs. The Trump administration invoked IEEPA by declaring emergencies related to sustained trade deficits, an ongoing economic emergency of historic proportions, and the fentanyl epidemic, arguing that the law's language authorizing the president to regulate the importation of foreign goods to deal with an extraordinary threat encompasses the power to impose tariffs. The case pivots on a judicial principle known as the Major Questions Doctrine, MQD. This doctrine holds that for actions of vast economic and political significance, the executive branch must point to clear congressional authorization rather than relying on ambiguous or broad language in an existing statute. The lower court, the U.S. Court of Appeals for the Federal Circuit, found that the sheer economic impact of the tariffs, estimated to total in the trillions of dollars over a decade, easily meets the major question threshold. Since IEEPA was traditionally used for non-tariff measures like sanctions and asset freezes, and makes no explicit mention of tariffs, taxes, or duties, the Federal Circuit ruled that Congress did not clearly authorize such action. Reasons and consequences. Reasons for striking down the tariffs. The primary arguments against the administration's use of IEEPA rest firmly on the U.S. Constitution's structure and the MQD. 1. Separation of powers. Article 1 of the Constitution explicitly grants Congress the power to lay and collect taxes, duties, imposts, and excises. Tariffs are, fundamentally, duties or taxes. Challengers argue that allowing the president to impose such sweeping tariffs without explicit congressional consent constitutes an unconstitutional delegation of legislative power and upsets the balance of power between the branches of government. 2. Statutory textualism. Critics emphasize that Congress has always explicitly mentioned tariffs or duties in the statutes where it intended to delegate such power to the president, e.g. Section 232, Section 301. The complete absence of these magic words in IEEPA, coupled with the law's legislative history focusing on sanctions, confirms that tariffs were not intended to be included under the umbrella term regulate importation. Reasons for upholding the tariffs. The administration and its supporters rely on a broad reading of executive authority in foreign affairs. 3. Executive deference. The president is seen as the nation's sole voice in foreign policy and national security. Some legal scholars and dissenting judges have argued that the MQD should be applied differently, or not at all, in areas concerning foreign policy, where the executive traditionally receives greater deference from the courts. 4. Functional interpretation. The administration contends that regulate importation is a broad enough term to include the imposition of duties as a mechanism to manage a national economic emergency, regardless of whether the statute explicitly lists tariffs. Consequences of the ruling. The Supreme Court's decision will have seismic consequences. If upheld, a ruling that upholds the tariffs would vastly expand presidential power, granting the executive branch a powerful, unilateral tool to enact broad economic policy, essentially allowing a president to establish an entire tariff regime based on a self-declared emergency without direct congressional action. If struck down, an adverse ruling would restore congressional prerogative over trade policy and force the administration to immediately cease the IEEPA-based duties. The administration has warned that this outcome could necessitate the refund of hundreds of billions of dollars in collected tariffs, potentially straining the Treasury and creating massive logistical and financial uncertainty for importers. Economists also predict that validating the MQD in this case could temper long-term inflation by reducing import costs. Prediction and solutions, the Plan B. Prediction. Based on the skepticism displayed by several justices during oral arguments and the conservative majority's recent trend of vigorously applying the Major Questions Doctrine to strike down major executive actions across climate, housing, and public health, such as in West Virginia v. EPA and the student loan cases, the Supreme Court is widely anticipated to rule against the broad use of IEEPA to impose tariffs. Solutions Plan B. Recognizing the legal vulnerability of the IEEPA approach, the administration has already signaled that tariffs are here to stay and has a Plan B to maintain an aggressive trade stance using other existing legal authorities. 5. Section 232 Tariffs, Trade Expansion Act of 1962, used for imports that threaten national security, e.g. existing tariffs on steel and aluminum. This authority requires a formal investigation by the Department of Commerce, which the administration has already initiated for sectors like autos, semiconductors, and pharmaceuticals. 6. Section 301 Tariffs, Trade Act of 1974, used against countries engaging in unfair trade practices, e.g. intellectual property theft. This authority requires an investigation by the U.S. Trade Representative. 7. Section 338 Tariffs, Tariff Act of 1930, allows duties of up to 50% on countries that discriminate against U.S. commerce. This is a dormant authority requiring only a presidential determination and notification to Congress, making it one of the quickest alternatives. While these alternative statutes require more cumbersome administrative procedures than IEEPA's simple emergency declaration, they provide a legally sound basis for maintaining an aggressive, targeted trade policy, ensuring the current trade regime, though altered, is not completely dismantled.